Hi, good afternoon. It's Mark Gracie here from the Digital Compliance Hub. Thank you for joining this webinar all about cookies and the recent guidance update. 183 million fines for BA and 99 million for Marriott Hotel. GDPR related things aside, I think that probably this change to cookie guidance, or more specifically, some very specific pointers from the Information Commissioner about cookie control and GDPR is probably being the most exciting bit of guidance of late, possibly even since GDPR came live last year. And whether you think it's exciting or not, is I'll leave up to you. So I'm hoping you can see the screen. You should hopefully see a hot air balloon and the title of the webinar on screen now. I'm recording the session, so I'll send a copy of the slides and a link to the recording at some point, possibly this afternoon or maybe early next week, so you can revisit if you need to. I'm probably going to talk for about 30 to 40 minutes, and then we'll have a Q&A. So if you've got any specific questions not covered throughout the session, or want to sort of question some of the things I said, then feel free to use the question panel in the GoToWebinar control panel to ask those questions, and I'll pick them up at the end. So as I said, my name is Mark Gracie. I run a business called Flowify Digital and a service called the Digital Compliance Hub. And I basically help businesses with their data and privacy compliance. And I'll talk a bit more about Digital Compliance Hub at the end as a sort of very quick sales message, but with a view to if you need anything further relating to cookies or anything else, then I can help you with that, and we can have a conversation offline about that. So let's get started. I won't go through anything further on that slide, but let's get started all about cookies. So just to be clear about what we mean when we talk about cookies, I'm going to use cookies as a general term to mean any kind of data that is stored on a device on visiting or a website or using an app. So historically, when we talked about cookies in the past, it would be you'd visit a website and a piece of data would be stored on your device. That piece of data, or the file that contains that data, is called a cookie. But in these days of very clever bits of marketing and tracking technologies, there are also things like pixels and beacons. I've heard some service providers refer to their sort of tracking, which is cookie based, referred to as beacons. And all of those bits of technology, whether you call them pixels, cookies, beacons, or whatever, if they are basically storing some data relating to a visitor to a website or the use of an app or some other kind of online interface, then that's covered by the cookie rules. And when I talk about cookies, I've been meaning all of those things collected, so that there aren't any different rules. If you're thinking I use a marketing platform like HubSpot and I use the HubSpot pixel to track people who visit my website and identify them, that's still covered by these cookie rules. So when I say cookies, I cover cookies, pixels, beacons, whatever you want to call them, relating to bits of data that may be stored from your website or your app or other interface where you're storing data on an individual's device. Now, in terms of the types of cookies, I'm not going to go into a lot of detail about the sort of more technical side of cookies. And if you read the ICO's guidance that they published a few weeks ago, that makes reference to things like persistent cookies and session cookies, which just basically means whether those cookies are always accessible and available on a device, or whether they are only for a specific session. So that might be, you might call a session as in an e-commerce shopping basket and remembering whilst you're logged in, and then that would be for that session of being logged in, that the cookie would be available. But I'm going to talk more around looking at cookies from a sort of essential and non-essential point of view. I think probably the easiest way to sort of break it down is that there are cookies that we'll talk about websites, but I mean, when I say websites, I mean websites, apps, etc. But when a website needs to use some kind of cookie functionality for the purposes of the website working, so for example, if you run an e-commerce website and you want people to be able to log in and see their orders, or you want them to buy things and put them in a basket, you may use a cookie to remember what's in the basket. And it would be really annoying if whenever you use the website, it forgot what you just put in the basket and you'd only show what you had just added to the basket. So cookie technology is used for those kind of things, and those are referred to as essential cookies. So if the cookie is absolutely necessary for the functioning of the website, and what you're trying to offer through the website will only work with those cookies enabled, then that's what we call essential, or the ICO talks about them sometimes as necessary cookies. So these are cookies that are needed for the functionality of the website, and without them, the user would have a bad experience and the website wouldn't work properly. That means you also have what's referred to as non-essential or non-necessary cookies. So these are ones that you may use because it's helpful to you, but it isn't necessary or essential for the website to function. And within these typically non-essential cookies, you can break those down into two, privacy intrusive and non-privacy intrusive. So to give you some examples, when we talk about non-essential cookies, most people talk about them in the sense of things like a Google Analytics cookie. So if you use Google Analytics on your website to track hits to your website, what pages are being looked at, that kind of thing, you don't have access to personal data in the sense that unless you're paying for some additional functionality through Google or through some other service, you don't get to know who the individual is. You just know that an individual looked at a range of websites, web pages on your website. Now, they would be non-essential because you don't need Google Analytics for your website to function. They're good to have because it's helpful for you. And they're not privacy intrusive because you don't know who the data relates to, so you can't identify a living individual from that cookie or the data stored within the cookie. And there's lots of other examples you possibly might have on your website that enable you to basically have functionality which helps your website, but is not essential. So those are non-essential, non-privacy intrusive cookies. Now, if your cookies are allowing you to be able to track and identify an individual, so there are services, a lot of marketing related platforms, I've mentioned HubSpot already, that's probably a good example to use. They enable you to, through the use of cookies, work out whether if somebody fills out a form on your website, it will store enough information to be able to identify that person if they reappear on your web page, or maybe they interact with you on social media and so on. So it builds this picture about visitors to your website to enable you to be much more very specific about your targeted marketing to that individual. Now, those would be construed as privacy intrusive because they either store personal data in the cookie or they're tracking behaviors of an individual. So to summarize what I've just said, you have essential and non-essential cookies. Essential are the ones that your website wouldn't work without. Non-essential are the ones that your website will work without, but you have because of the functionality you've put on your website, things like Google Analytics and tracking pixels for potentially Facebook and HubSpot and things like that. And then you break those down into two. Ones which are privacy intrusive, which means you would be able to identify, or because the cookie stores personal data, they would contain personal information or related to an individual, or non-privacy intrusive, which is you have no idea who the individual is. You just have you just make use of a generic bit of code for the cookie. So I hope that's clear, and I hope I've not muddled that. I'll try not to talk about it anymore, otherwise I'll probably muddle it even further. But it's important to understand those kind of differentiations between the different types of cookies and how they figure, particularly relating to what's coming with the what has happened with the new guidance. Now, in terms of the law, cookie law isn't a new law. This has been around since the Privacy and Electronic Communication Regulations was introduced in the UK in 2003, and the or PECA as we like to call it. When PECA came in, it basically set a foundation for what's needed for cookies, and it basically said if you're going to place a cookie on a device, you must tell the individual that you're doing so, and they must consent to that happening, and with some nuances around essential and non-essential. Basically, if the website needs a cookie to work, it's an essential cookie, and the rules say you can place those, you just need to tell people that you're using them. They don't have to have any choice in whether you place them or not. If you're using non-essential cookies, you need to tell the individual that you've placed a cookie, and you need to get them to give some kind of a consent. Now, under the old regime, what that consent looks like was the old Data Protection Act 1998, and how it set out consent, which allowed us to make use of essentially a soft opt-in or an implied consent. And what that meant was that what we had was typically what sounded like a lot of work to get people to consent to the use of cookies was actually what I'm sure that you possibly have on your website now, or you will have seen a cookie notice that basically says we use cookies, click OK to say that you accept that. Otherwise, read this information about what cookies we use and how you can turn them off. And the turning off was very much browser led. So you can go into your browser and say, I don't want to allow cookies. But the thing is that breaks functionality for cookies across all websites, regardless of what websites you're visiting. But that was allowed. And that's why up until GDPR started happening, most websites had a generic, we're going to use cookies. You don't really have a choice about that. Click OK to accept that that's what's happening, but don't forget you can always turn them off if you want to. And that implied consent was satisfactory. The key thing where data protection fits into this is the quality of the consent, or the consent that appears in the data protection law. So even though PECA sets out what you need to do, so what you can and can't do, the data protection law tells you how you actually do that in practice. And the key bit there for cookies is consent. Now, just to confuse matters, when GDPR happened, so just stepping back a bit, pre-GDPR, of course, as we said, we did have this concept of implied consent. So in a marketing world, untick this box if you don't want to receive our marketing was perfectly acceptable. Of course, in a GDPR world, that's not. Around the time that GDPR came in, there was a bit of uncertainty because GDPR has very strict consent rules. So it has to be open and transparent. It has to be a positive and affirmative action by the individual to indicate they're giving you consent, and you have to be able to demonstrate that that consent was given. So I sort of kept an eye on this when GDPR was happening, and probably similar for lots of things, a good sort of tracking point is to look at what the ICO is doing, because if the ICO are doing it one way, then they could never argue that you're doing it wrong if you're copying what they're doing. And initially, they had the strict consent rule. So that was basically saying, we're using cookies, can you give us permission to use them? And of course, that fits in with the model that PECA sets out what the rules are, and GDPR tells you what the consent mechanism should look like. But then they swapped it, and all of a sudden, it was back to the old, we use cookies, click OK to confirm, read this policy here to explain a bit more about your cookie, about the cookies we're using and how you can turn them off. And so there was I would say a period of uncertainty, and it got horribly confusing, because I was advising clients about, you need to have proper cookie consent now, because that's now GDPR consent, and we know how strict that is. And yet the ICO had done it slightly different and suddenly changed, and they tend not to tell people when they change things very, very much. You get to see notices, but they're not very good at sort of communicating them across in a more useful way of communicating across multiple platforms and telling people that things have changed. And then a few weeks ago, I think it's probably the end of June, I'd spotted that they'd actually reintroduced a much more stricter we're using cookies consent mechanism, and that made me question, well, why were they doing that? Because everybody's still using this sort of implied consent, even though implied consent doesn't exist under GDPR. And then they started saying, well, actually, we're going to change. We're setting out some new guidance that basically changes how this works. So in a post GDPR world, the strict consent should have always been the case, but it wasn't. And now with the new ICO guidance, the strict consent that comes with GDPR is now a prerequisite. If you need consent, it has to be GDPR consent, and with regards to cookies. So what this means actually in practice is that if you're using essential or necessary cookies, you don't need consent, you can carry on using them. So for things like user management, security, network or system functionality, the control of baskets on an e-commerce website, keeping people logged into their accounts, that kind of thing, that's all necessary. You don't need consent for that. So there's no change for that. But the big change is on the non-necessary, whether they are privacy intrusive or not. Non-necessary or non-essential cookies now need GDPR level of consent. So just to remind you of that level of consent, that is open and transparent, a positive action by the user to confirm they give that consent, and you need to demonstrate that it was given in the first place. Now, they've gone further than just being that kind of, that would have been quite vague if they'd left it like that. And they've actually been very specific about different types of cookies that will now need consent. And I think probably for most organizations, the big one is if you want to use analytical cookies that aren't privacy intrusive, so they're not essential, but they're not privacy intrusive, you must still get GDPR compliant consent. If you're using privacy intrusive cookies, you've always needed GDPR compliant consent, and even the old guidance said that you needed that in the first place. So in some ways that's not changed, but I think they've certainly clarified this a lot more. So just to repeat, if you're using essential cookies on your website, you can carry on using them. You don't need to have consent. You do need to explain that you're using them, so you still need your cookie pop up, and you still need some statement, be it a cookie notice or as part of your privacy notice, but you don't need specific consents from the user to use those cookies. For all other cookies, you need consent, whether they're privacy intrusive or not. And again, you have to be open and transparent about it. So you need to have that cookie banner that pops up and explains this. You need to have details in your privacy or cookie notice that sets out what kind of cookies you're using and how you use them and what you're going to use the data for. But the big, and that's the big change, is it doesn't matter whether they're privacy or non-privacy, you now need consent, and that consent has to be GDPR compliant consent. Now, what that means in practice is that your cookie banner now needs to pop up and say, hey, we would like to use analytics cookies. Can you toggle the switch or accept a setting below to say that you're happy for us to do that? Now, this is going to be a real bind for anybody, because if you implement that and nobody, so if people ignore your banner, if it pops up and they just keep it at the bottom of the screen, or it slides in from the left and you just minimize it so you don't actually accept anything, or you accept cookies but you don't toggle to say, yes, I'm happy for you to use analytics cookies, you're not going to see how many hits you get to your website, because those analytical cookies won't be turned on and therefore it won't be working. So I think this is, well, I don't know, maybe a personal opinion, a slight overreaction and making a bit of a nuisance, or a significant nuisance for most websites, because all of a sudden, most people probably aren't going to take the option to say, oh yes, of course I'll be helpful and let you know how many web pages I've looked at on your site, or I'm not going to even worry about whether they're intrusive and understand who I am personally. I'm just not going to accept anything. So all of a sudden all that will work. And of course, if you've invested in some of the tracking pixels and beacons that we spoke about before with HubSpot that allow you to sort of track somebody's individual behavior, yes, the rules are very clear about that, and you've got no choice. But of course, you can't rely on somebody still using your website to demonstrate that they have given you permission to place those cookies. You will need to set those out individually so that there are individual consents for all the different types of functionality that the pixels or the cookies are providing. So quite a significant change, which is why I said at the beginning that it's probably one of the most exciting things that has happened in recent months relating to GDPR or privacy related matters. Of course, the PECA rules sit alongside GDPR, so they still exist as they've done since 2003. The significant bit is the fact that GDPR introduced a different set of consent rules, and the ICO have very clearly clarified that those consent rules need to mirror what GDPR says in PECA. So if you need a consent for a cookie, it now needs to be GDPR compliant consent. And the only ones where you don't need consent is going to be these essential have to work, are needed for the site or the app to actually work. So what kind of things can you do to meet that compliance? Just to keep you on the edge of your seats, there is a sort of a big but coming towards the end on the next slide. But in a general sense, what do you need to be doing? Well, first up, you need to understand what cookies you've got running on your website. Hopefully, you will know what that is because, or you should know what that is because you've introduced the functionality that's introduced the cookies in the first place. But if necessary, carry out what the ICO refers to as a cookie audit, which basically looks at what cookies you've got running on your site. And you need to be mindful that third-party applications you might have running within your website might introduce their own cookies. So for example, and the ICO talks about this, these third-party cookies might arise because you're using some kind of sharing plugin in your WordPress website, or you're using some functionality which allows somebody who has an open account in Twitter to see their account listed in the Twitter feed that you've got on your web page, for example. Now, all of these applications and services that you might be using are possibly using cookies to achieve that. And if you use things like you've got banner ads and stuff on your website that are served through some kind of ad network using Google AdWords or something like that, then there's a possibility, or probably a high likelihood, that you've got some cookies enabled for those as well. So don't think, well, I only use Google Analytics, that's the only thing I use that I know uses cookies. Just double check, because there's a possibility, depending on the complexity of your site, that you're using a lot more than that. So identify what cookies you're using is the key way of doing it's the first thing to do. There are different functionalities in browsers that enable you to do that, but you might need to talk to your website designer or developer to just confirm what they think is there in terms of cookies. So for example, in Google Chrome, when you're viewing a web page, you can go to view developer tools, and in the developer tools you can actually see what cookies are there, and it will give you a list of codes which represent the cookies, and you might have to Google what those codes are to find out which app it relates to. You then need to decide, of this list of cookies, which ones are essential to the functioning of the website and which are the ones that are non-essential. If you run a basic website that just uses Google Analytics, is not doing anything with any sort of complexity in terms of added on features and integrations of AdWords and adverts and social media sites and things like that, then if anything, you've probably got a cookie just for Google Analytics. But nonetheless, you still need to work out which ones are essential and which are non-essential. You've then got to work out the wording for your cookie notice and your privacy notices. Sorry, cookie notice or your privacy notice. You can have both if you want, but you can cover off your cookies in your privacy notice if you wish, that set out what you're doing. So remember, the right to be informed in GDPR says you have to tell people why you've got their data, what you're going to be doing for it and with it, and why it's lawful. So even though, and I think this is a challenge for some people to sort of get their head around, is that, well, if my cookie isn't collecting personal data, then why do I need to define that? Well, you need to define that because PECA says cookies need consent. Consent is derived from data protection law. Data protection law is GDPR. GDPR consent looks like right to be informed, consent, and a demonstration of consent. So you will need to set out, as I say, in a privacy notice or a cookie notice, or in both, or in just a privacy notice, that you're using cookies, what kind of cookies you're using, what data is being collected through those cookies, how you use that data, and you also need to explain why you would, what that consent mechanism looks like in terms of how they can opt in and opt out once they've opted in to the cookies in the first place. So you need to set all that out. So you have to be open and transparent about it. You will also need some functionality which gives you the opportunity to offer up a notice saying we use cookies, and you can read about them in our privacy policy. But we'd also like you to opt into using these cookies, which will help us develop our site, improve the services we offer, etc., etc. But you need to have that consent switch off to enable and encourage people to obviously turn it on so that you can get your analytics and such. But just remember, the key here is consent can't be pre-ticked. It has to be unticked by default, and you've got to ask the individual to tick it to give you that consent. Now, in terms of recording your consent, you don't need to have some cookie that records an individual gave you at this particular time consent for the purposes of demonstrating that consent. You just need to be able to demonstrate that your cookie mechanism is clear enough and works, that the only reason that cookie would have been sent or used would have been because they would have flicked this switch in our cookie consent banner. And that comes down to the accountability principle in GDPR and you being able to demonstrate that you have you're acting within the law. So document your approach. So you need to have an internal, well, you need two things. You need an internal piece of documentation that sets out how your cookies work and how you've met the GDPR requirements. But you also need to make sure internally everybody understands, and particularly the IT guys or the developers that you're using, that they can't just suddenly turn functionality on without considering what the cookie implications are for that. And just to clarify again at this point, because I've seen people saying, well, all my cookie stuff is in my privacy notice. You need to make it clear that you are using cookies, and that's why I talk about having a banner. So you have typically a pop-up on something on your website that pops up and tells you that that you're going to be using cookies, as well as the information that's in your privacy notice or your cookie notice. And that's now even more important because you need this mechanism, unless you're not going to use cookies other than essential ones, to get that consent. Now, in terms of what functionality is out there to enable this, well, that's going to depend on the way you run your app or your website. You might, if you've got a developer that helps you with that, then they may have their own views about how to implement that. There are a number of cookie plugins for platforms like WordPress, although those tend to be not as strict as I haven't looked in the last couple of weeks to see whether they've changed anything, but some of the common ones or the recommended ones within the WordPress plugin depository don't tend to meet this criteria of setting cookies, or they're quite complicated to configure so that they are. The one the ICO use, and I've used them as well, it seems to be relatively straightforward to configure a simple cookie usage, like just for analytics, for example, is provided by a company called Civic, and you have a WordPress plugin which you can add, and you can configure that using a key which you have to use on the website. So you kind of have to register with the website for the use of the cookies, their cookie controls, and they give you instructions about how to configure the plugin. That is free for a basic setup. If you need to do more complicated things across multiple sites or multiple different types of cookies in very, particularly some of the more privacy intrusive ones, you'll probably need to pay a subscription to use that service. So again, I think the best advice is speak to whoever it is that develops your website or looks after your website to see what they can put in place. But before you run off to do that, there is this big but in terms of what the guidance says. And on the face of it, as is always the case with these kind of compliance tasks, it all seems very black and white. You must do these things, you can't do these things. And And you read the guidance. If you've looked at the guidance, you'll see this. The guidance goes all the way through telling you what you can and can't do, interpreting the different types of cookies and whether you need consent and don't, and that you confirming that you need consent for analytics cookies and so on. And then right at the end, there's a section kind of tucked away about how they will enforce it. And the enforcement is that they have the ability to enforce under the Privacy Electronic Communication Regulations, or PECA, and that actually stays the same as the rules according to the 98 Data Protection Act. So the fine mechanisms and stuff like that won't be GDPR level. They'll be, I think it's up to $500,000 under the 98 Act, because that aspect hasn't been adopted between PECA and GDPR. But nonetheless, they have the power to enforce non-compliant businesses who aren't following the cookie controls clearly. And then they kind of say, how, and I've underlined it on this slide, however, it's unlikely that from a priority point of view that they'll take any action on low-level cookies, so probably non-privacy intrusive cookies, unless there's an indication that there's some risk to harm. So we've then, and actually there's a second line that's sentence underlined there. For example, the ICO is unlikely to prioritize first-party cookies used for analytical purposes where these have low privacy risk. So that kind of is them saying you must do these things. So for Google Analytics use cookies. You must declare you use those cookies. You need consent to be able to place those cookies before you can start recording your analytics. And provided that those Google Analytics cookies aren't storing any personal data or enabling you to track people individually, you just need, you would class those as a non-essential but non-privacy intrusive cookie. But you still need GDPR compliant consent to meet the regulatory requirements. But then it says in the enforcement action, but we'll probably not do anything about that because of the low privacy risk. So that puts everybody into a difficult situation. Obviously, if you're using privacy intrusive cookies, if you're using services like HubSpot, or you're using some other service that enables you to track individual behavior or identify an individual, you've got no choice. You need that cookie consent and you're going to have to do some work. But for the majority, particularly of small businesses who probably only have Google Analytics cookies turned on, you've got this dilemma. Do you follow the instructions black and white? It says you now need a cookie banner that gives somebody the functionality to turn on the ability for you to place a Google Analytics cookie, or do you run the risk that it would be non-privacy intrusive and therefore a low risk, and therefore the ICO indicate they might not take any action? I think this is a real mess that the ICO have introduced. They either tell you what the law is and tell you what their expectations are in terms of what you should be doing and stick to it, not tell you, oh, and by the way, we might not enforce, but we can't guarantee that that won't be the case. And I took this up with the Information Commissioner's Office, and they said, well, that's up to you. You need to decide. You run the risk of not being compliant, and if we were to investigate you for whatever reason, then you would not be compliant. Whether we would take action or not would depend on the circumstances and the situation and a number of other factors, but basically they won't commit to whether they would definitely not enforce it or not. So as I said, I think this is a bit of a shambles, because you can't say here are the rules, oh, and by the way, we may or may not enforce them. It's up to you. Most businesses want some clarity on these kind of things. So this is why it's a big but. So the previous slide told you what you should be doing, and the stuff I've talked about already is about the consent and how that needs to look from a GDPR consent perspective. But ultimately, it's down to you about whether you need to panic about this. I would suggest that you probably don't need to panic about it, but you do need to think about it carefully, and you need to consider the issue of, from a risk management point of view, about whether you want to implement this this cookie consent for non-privacy intrusive cookies like Google Analytics. I mean, as a consultant in this area, it puts you in a very difficult position, because you can't advise a client not to follow the law, but you can give them some guidance that actually the law may not actually be enforced in the way that it originally set out to possibly be enforced. Yeah, if you've got some questions about that or some thoughts about that, then use the question panel because I'd be interested to know what you think. You could say, well, it's business as usual. Let's carry on with the we use cookies. If you don't like it, turn them off in your browser approach. It doesn't meet what the regulation says, and it doesn't meet what the guidance says. But if those cookies are just literally Google Analytics cookies, then there's a good chance that you'll get away with it until we start seeing people enforcing, see the ICO or even other regulators enforcing it in more details. And this is going to be a European-wide thing. This isn't just the ICO's approach. This is much wider than that. And we may even see some more stricter enforcement when the new e-privacy regulation happens. If it does happen, the latest I saw this morning, somebody is predicting it's probably not going to be until 2021 until we see it, and it's sort of being held up for various different reasons. And I think part of that is nobody can agree that the full set of rules across Europe. And of course, in the UK, that's complicated even further by Brexit and how that law may be implemented in UK law in a post-Brexit world. So there's a lot of interesting stuff, or at least I find it interesting to think about. So I leave you with that slide as a sort of having done this presentation and said, these are the changes, this is what it means in practice. This slide kind of says it's up to you to decide whether you want to implement it if you're, if you're not using if you're not using privacy intrusive cookies. If you're using privacy intrusive in cookies, the advice is you need consent. You've got no way of getting around that. And if you get found out not having the proper consent mechanisms, then there's a good chance that it will be enforced. And you can go onto the ICO's website actually and see the kind of cookie complaints they deal with. And I can't remember the precise figures and for what period they were, but they amount to about 300 to 400 complaints a month about cookie related matters. So so take that as you will in terms of maybe a risk assessment. But I'd say that there's probably no need to panic because of this willingness if you're just using Google Analytics cookies. But you do need to think very carefully about whether you want to take that risk of something happening. It could be completely outside of cookies and your website, but something that leads to an ICO investigation and they sort of tag on, oh, and by the way, your cookie notice isn't compliant either. So we've taken that into consideration. Who knows? But I think it's bad form by the ICO to set you up for what you're supposed to be doing and then sort of saying, but we may or may not enforce it when it comes to the crunch. Anyway, so in terms of, so this is the very quick sales pitch. In terms of needing some help, if you want to try and interpret what I've said in a bit more detail in your very specific circumstances, or if you need any other help relating to privacy, maybe be that email marketing compliance or of course GDPR, then I'm here to help with that, and I run a service called the Digital Compliance Hub. There's essentially 3 strands to the service. I run a GDPR or a help desk or a helpline. It's a subscription-based service. You get access to unlimited email and phone support for things to help you when you need it most. So it doesn't matter whether you've got to try and interpret whether you've had a breach, and if so, whether it's reportable, or whether your cookies are right now and all that kind of thing. Then the help desk is a good way of doing that. I'll also offer outsourced compliance management. So if you need a data protection officer or you want somebody to take responsibility for it within your organization, then let's talk about that. And I do ad hoc pay-as-you-go support and help. So yeah, I do a lot of sort of one-off privacy notices and discussions with people about very specific issues that they're facing with their clients or otherwise. Yeah, so if you are thinking, actually, I need to talk to somebody about this cookie stuff and try and get my head around whether it is something I want to implement or not, then you probably want to go for the pay-as-you-go option, which is based on an hourly rate, and get in touch if you want to sort of discuss what those options might look like. So that's the end of what I wanted to say. I hope I didn't muddle it too much, because there's quite a lot to cover, and but it's actually quite simple until it gets confused with the ICO saying that they may or may not enforce at the end. But I hope I covered everything that you were hoping to get covered. It was certainly a popular topic. I had rather a large number of people signing up, which was great. As I said, there's a questions panel in the control panel, and you can use that to ask any questions. So there's nothing there at the moment, but I'll just leave it a few minutes, and if anything comes through, I'll pick that up and answer those questions. If there aren't any questions, then I'll end the webinar. Okay, somebody is going to ask me a question. Okay. And some thank yous. Thank you for those. Always welcome to get a bit of feedback. Okay, so a question, right? So thinking about websites that use ads to generate income, this could potentially end their business. Is that correct? Yes, I suppose you could put it that way. I think I think this falls into, so if you're relying on cookies or some kind of mechanism, which of course a lot of these technologies will be using, to be able to place cookies on a device so that you can see that actually they were on Amazon 10 minutes ago looking at a pair of shoes, and therefore you want to advertise your products according to that, then yes, you're going to have some issues. The ad tech sector as a whole is currently under the spotlight with the ICO, and I think the regulators across Europe anyway, because there's a whole question around how do you get the clear consent you need to enable that kind of tracking. But yeah, I think the short answer to your question, Midas, is yes. There could be potential issues here, and it's the same, I think, with Google Analytics. Google Analytics performs an important function for pretty much every website, or similar analytics tools do. You want to know whether your website's being viewed, and if it is, where are they going? And if they are going places, why are they not clicking on the contact you or following your call to action? And why is the phone not ringing? All those kind of questions. You're going to have to now, if you follow the rules strictly, rely on somebody ticking a box or flicking a switch to say that they don't mind you having this information available, even though it's not privacy intrusive. And to be honest, and I do it myself, if there's an option to reject cookies, ignore the message or whatever, I take that. And but yeah, I think for me, for my own websites, it's a real nuisance, because I suddenly can't have an accurate picture as to who's hitting my website. And if there are cookies involved in the ad tech transactions that are happening across multiple sites, including your own, then yes, there's potential revenue implications. Okay, so there's quite a few questions coming through. I'm just having to flick through them to see whether they're actually questions or not. So bear with me a second. Yeah, so Jeanette's saying that for things like Facebook, where people like your page and follow it or like a post, are they, I think your question there, Jeanette, is, are they giving you consent? Well, I think this is Facebook in particular. So Facebook will be using cookies, and Facebook should be explaining what cookies are being used. From your use of cookies and things like that, I think that the only overlap is that if you've got a Facebook functionality which shows that Mark Gracie is logged into Facebook as Mark Gracie, and when they look at your website, Mark Gracie sees his login so that he can comment on some post that you had on Facebook. So you're sort of essentially showing your Facebook page posts in your web page, sort of embedded in your web page, and that person is showing logged in, then there will be a cookie interaction of some kind, or some kind of pixel and stuff like that. And those are the kind of things that you also have to bear in mind. And the ICO are quite clear about these third-party cookies being non-essential, and therefore you need consent for them. Whether they are seen to be privacy intrusive, well, potentially the fact that you are able to see on your website the individual through the plugin or whatever it is logged in, then there is some transfer of personal identity, and they probably need to be you need to consider those carefully. But I think people liking your Facebook page whilst they're within Facebook, that's all covered by Facebook. That's not something you would have to worry about from a business point of view. That's down to Facebook getting it right, and that's the platform you just choose to use. So I hope that makes sense. Yeah, so Midas, your BuzzFeed question, and there's multiple sites like it that do all of these things, and there's also I'm sure everybody's seen them, these websites. You go to read something like a newspaper article online, and you suddenly can't scroll any further until you click accept for a load of cookies. They're getting a bit better because they're supposed to give you the functionality to turn them off. So in that respect, yes, that's going to, going back to your previous question, that's going to impact the revenues that come in through those. I didn't touch on it, but actually it reminds me of a scenario where, and the ICO talk about this in their guidance, that these kind of splash pages which stop you from doing anything until you've given proper consent and stuff, are probably non-compliant in the true sense, because the GDPR talks about openness and transparency and what the consent rules and things like that, but it also talks about about it not interfering with the for want of better words, the customer's journey whilst using your website. So whether we'll stop seeing those big splash pages, which I find personally quite annoying, popping up telling me about what cookies are being used. A, those cookies now need to be controlled better, and B, there's a question about whether it's acceptable to plaster a whole screen with a cookie notice, which is probably over the top in terms of what the regulation requires, and the ICO hints that it's probably not compliant either. Yeah, and another question, thank you, Midas, about that's actually from a sort of charity, and actually I don't think it is just charities. I think a lot of sites benefit from being able to demonstrate that they're getting reasonable web hits, so that they can get, sell advertising space, or in some instances I know of organizations who have sold their online business on the fact that they get thousands a day of hits to their website. Well, if they follow the strict rules around cookies that require you to have a consent tool to tell people to flick a switch so that you can use the cookie for that analytical purpose, you're not going to be able to demonstrate that I think that's my whole point of why it's really annoying with the Google Analytics example, because you will no longer be able to demonstrate whether those stats are the right accurate stats unless somebody comes up with a non-cookie related approach to presenting analytics. Okay, so I've got to the end of the list of, oh no, one more question. Yes, thank you, Midas. A fun question, as it's put. Will the Article 11 copyright directive stuff put an end with this as well? Put an end to the internet as we know it? No, I don't think so. I think people will find ways to either get around it in another way, and then we'll end up with another set of regulations in maybe 10, 20 years that addresses some issue that people never thought of at the time, or it will not be that much of an impact, and there'll be lots of evidence where the ICO haven't enforced it. So for most people, nothing will change. But for the privacy intrusive stuff, then yes, I think it will have an impact. It doesn't stop you doing it. You just got to ask people for the permission, and it's maybe about educating visitors to your website about why it is of use to them that that they allow these kind of things. I'm sure we'll see over time different implementations of technologies that achieve the same but don't make use of cookies. And for the Article 11 copyright stuff, I think that's so for anybody who doesn't know, there's a new copyright directive in Europe that has gone through the various different checks and balances at EU level that basically require certain companies to identify copyright infringing material and make sure that a license is in place with the individual who put it on their platforms. Those platforms already have, I think that I'm possibly oversimplifying it, but those kind of platforms that are going to be affected by that regulation are going to be the likes of Googles and the Facebooks of the world. I can't remember what the specific rules are now, but there is a limit to who's caught by the regulation, and I think the key thing there is that places like YouTube, for example, they already have technology in place which spots copyright infringing material and tries to address what that might mean to them as a platform. Content liability in general is something I have a background in as well. In terms of internet content, has been a problem for the last 20-25 years, ever since the internet started getting more mainstream, and I think it will continue to do so because there will always be ways around it. And I think I've also seen people saying that these new copyright changes will probably just lead to people selling services that enable you to control licenses and things like that. So I realise it was a fun question. Maybe I gave a bit too serious answer, but no, I don't think it's going to be the end of the internet as we know it. Okay, so I've not had anything further through other than some thank yous. So again, thank you for that. It's always good to have positive feedback. I will therefore end the webinar now. As I said, I've been recording it, so I'll at some point in the next couple of working days get a link to the recording and a copy of the slides that you can make use of if you want. And obviously that will also include my contact details. So if you need to get a bit more insight or help for your specific scenario or situation, be that cookies or any other aspect of GDPR or data privacy, then get in touch. Thank you very much for joining. Enjoy the rest of your day and have a good weekend, and hope to see you on a webinar or speak to you soon. Thanks, bye.